I would like to invite our speakers to come up, and especially I would invite our very important student president, our president of the Native American Student Council, Kelsey, Lawson, to come up and give our opening words, and then I'll introduce myself and the speakers.
Hi everyone, I'm Kelsey and I'm president of the Native American Student Council. So first and foremost, I just wanted to formally acknowledge that we are on Piscataway land, and I think it's important that we pay our respects to the Piscataway peoples and call attention to the need for a better relationship between Georgetown and the people whose land we're standing on right now. So the Georgetown Native American Student Council would like to thank the Institute of Americas, specifically Laura, for reaching out to us and allowing us to participate in this opportunity. We can see how our own goals and values align with those that are showcased here. But our tiny group of 4 Native students, we have been working tirelessly to advocate for more Indigenous visibility and recognition at Georgetown. We started circulating a petition calling for the university to provide better support services for Native students on March 18th, and we received over 600 signatures from undergraduates, graduates, staff, faculty members, and even Congresswoman Deb Haaland, one of the first Native Americans ever elected to Congress. So we know that the Georgetown community is supportive of our cause, and because of this, we need to hold the administration accountable. We delivered our petition to the President's office on April 3rd, because this month is Native American Heritage Month at Georgetown for some reason, as opposed to November, as it is nationally. But yeah, we delivered our petition on April 3rd, but we have not yet been contacted about what the university plans to do moving forward. So we urge everyone to contact the President's office if you can to support our cause. And we also want to stress the importance of communication between Georgetown and Piscataway peoples. While a symbolic land acknowledgement is something that we think is necessary for the university to implement, and something we call for in our petition, we want to recognize that this alone is not enough. Georgetown University is currently proposing to raise 240 acres in the Nanjamoy Forest in Maryland for a solar project that would power half the school. And while green energy is a step in the right direction, there needs to be a recognition of the need for consent from affected Indigenous communities, because this forest is Piscataway land. And so without explicit tribal consultation, the university is committing a human rights violation. There are alternative sites that can be utilized for the solar project. Renewable energy can be done in a manner that benefits everyone. Again, the Native American Student Council would like to thank the Institute of the Americas for hosting this event and for giving us space to engage in important dialogue. We urge everyone in attendance to be aware of how they can engage in advocacy work as it affects Indigenous communities and their human rights on a local level, and be cognizant of what injustices might be occurring to the people whose ancestral lands we're standing on right now. So thank you.
Again, that was Kelsey Lawson, and feel free to get in touch with her or with me about Indigenous Studies at Georgetown. I'm Marjorie Mandelstam Balzer. I'm co-founder, along with Betty Jacobs, who's sitting in the audience in yellow, of our fledgling Indigenous Studies, we hope to be soon, initiative. And we are delighted to be able to welcome you here today to Indigenous Peoples and the Inter-American System of Human Rights, Securing Pathways to Justice, ? And indeed, in addition to welcoming our panelists, who I'm going to ask to come up to the front quite quickly, I want to welcome the audience and give a few credits and thanks. The Institute of the Americas is a French consortium of universities whose goal it is to promote interdisciplinary research in the Americas. And Laura Cahier is their representative here and is the organizer of this important event. So we want to thank Laura first and foremost. She's a PhD student from France who's been contributing quite a bit to the Georgetown community as well, a doctoral candidate, soon to be a doctor. I'd also like to thank partners in the event, Unrepresented Nations and Peoples Organization, and we have one of our speakers from there, the director, the Center for Latin American Studies at Georgetown, our Indigenous Studies Working Group, and I want to put a little plug in. We have a website, and you can go to it, indigeneity.georgetown.edu, for resources and context for this program and a number of others. And also the French University of Aix-Marseille and its International and Regional Law Research Center. We consider this a wonderful event, and it's an opportunity to begin to organize various conversations, especially starting today, on important issues in the moving target topic, Inter-American Indigenous peoples' justice. And one of the things that is most crucial here is that our speakers come from Indigenous organizations and from Inter-American human rights organizations. They're all insiders to various degrees and in various ways. Some are Indigenous and others are allies, but they're coming from different backgrounds and different perspectives, even within a kind of supportive concern about justice. We want especially to explore today issues of advocacy, strategy, resilience, and problems of the challenges that range from social and political to economic and everything else. Our speaker presentations are in the order on your program. I hope everyone has a program. You all have these gorgeous things with colored bios there in the back, and we can give them out. We're also going to have Laura read a short version of summary of the statement that is being passed around as well by José Otero, and I might add, it's quite dynamite, it's quite chilling, so it's important to read. After the presentation, we'll open up our multi-log to discussion and questions from the audience. So first, Juanita Cabrera López. Our first speaker is Executive Director at the International Mayan League. She will be speaking on Indigenous peoples' political and spiritual resistance against 526 years of violence, violations, and impunity.
Do you want us all to come up?
Yes. I had thought so, but actually,
Yes.
that's
Makes you feel more comfortable. I had a feeling that would be the case.
we weren't sure. I'll be honest with you. We had all sorts of RSVPs for people who clearly are not thronging the room and creating standing room. So we were not sure that there would be room unless you sat in the front. So there you go.
Good afternoon, and thank you so much for this invitation. And I also want to thank you for reminding us, and as we always have, we have a great relationship with the Piscataway Nation and the Tayac family as Indigenous peoples who have been displaced and living in their ancestral territory. So I always recognize their family and the lineage that has always been here. I also want to acknowledge today that in the Maya calendar is the Day of the Deer, which represents for us the 4 cardinal directions. And it's also a day of balance in recognizing the diversity of our Indigenous peoples and also seeking justice, which coincides very well with today. So I'm not going to speak the whole time. I'm going to start with a small video of some of the advocacy work that we as Maya people have done through our traditional government structures, specifically around the issue of Standing Rock. As was mentioned before, much of the work with Indigenous peoples focuses on our human rights violations connected with our lands and territories. And so we, as Indigenous peoples, went to Standing Rock, not as an NGO, but as traditional authorities through our autonomous structures, government-to-government relationship, to share our solidarity during the Standing Rock crisis. So I share this video because it is emblematic of some of the way that we as the International Mayan League have worked with our leaders, whether it's our leaders from Guatemala or also working with tribes and nations here in the United States. Again, through our traditional government structures, through our right of self-determination, through our right of autonomy. And as you saw in the video, ensuring that everything we're doing is also rooted in our traditions, in our ceremony, and that has been a cornerstone of our survival. If you look at this map, it shows tribal nations all throughout what is now called the Americas. So before the invasion of Europe came to this continent, there were already civilizations on here. That means distinct nations, languages, ceremonies, cultural ways, trade routes, economic systems, whole civilizations. It wasn't an empty place. We look further south, we see Mexico, the diversity of our indigenous peoples, our relatives in the area that's now called Mexico. And then here, synopsis of Guatemala, where 22 distinct Maya nations, Xinca and Garifuna people. And that means that we don't speak dialects, we have our own distinct ceremonies, languages, because each group is a distinct nation. Like for instance, I'm Maya Mum, you can see my territory, it's the yellow piece on the map. I'm also here with my mom. I'd like to acknowledge my mom, but she's also a traditional authority from our people and an ancestral leader, and you already saw her in the video, so we're coming from the Mam region. Now, I show this because, again, I want to reiterate that sometimes people think that they were coming to an empty space that was up for grabs, up for displacement, where in fact there were already tremendous civilizations and networks and very advanced in astronomy, in architecture, in agriculture, in medicine, and this is a narrative that is often not told. Because of the way that we as indigenous peoples have lived with our Mother Earth, which is part of our cosmovision, much of the Earth's natural resources, though we call it goods of Mother Earth, whereas Western-based system calls it natural resources or natural resources for market. Much of it exists in our lands and territories. So about, I think the World Bank came up with a stat that was saying about 80% of the world's biodiversity exists in indigenous peoples' lands and territories. So what that has meant is that while we're practicing our ancestral ways, while we're conserving our lands and territories and protecting our home, we've also ended up conserving a huge portion of the natural resources or goods of the earth, and that means that we're also under attack by transnational corporations. So in this map, what you see here are hydroelectric projects. Now, more often than not, you think hydroelectric dams are good projects, they're green energy, but in reality, as has already been alluded to with some of the solar projects in this area, if you're violating a nation's self-determination, their traditional government structures, not consulting with them, and going through and imposing projects, you're violating their human rights. And when our leaders stand up to these projects, this is what happened. This is a map where all of those dots are people who have been assassinated as connected to those hydroelectric projects. This is 40 human rights defenders since 2005. But actually that number is a lot more. Just last year in Guatemala, in a span of 4 months, 8 of our leaders were killed, connected with different projects. So when we get up and we stand up for our rights, not only are things like Standing Rock where the military came in, but at the most extreme cases, there's assassinations of our leaders, or in very extreme cases, which all of our peoples have endured, there's genocide. So in Guatemala, we talk about eras of displacement in our peoples. We talk about the first invasion being 1524, the arrival of the first ships, and then a wave of theft of our lands and dispossession. So we talk about the liberal reform, and then the third displacement, which was the genocide and the wars of 54 through 96. And then now we're living in the fourth era of displacement due to transnational corporations. But this is just Guatemala, but you could probably replicate this in the United States, in Mexico, in Canada, and all throughout the Americas, because us as indigenous peoples, we have similar history regardless of where we are. And so this is part of the reason why it's so important, not only because we have the right of self-determination and sovereignty, but also because we become stronger when we have diplomatic relationships between our nations. And we have that right to express it because we are sovereign nations. So I talked about the number of human rights that have occurred when our people speak out, when we defend our lands and territories, rooted in conflicts over our lands, territories, natural sacred elements, persecution, criminalization, militarization, genocide, structural impunity. We have missing and murdered indigenous women and girls, femicide, we have lack of access to economic opportunities, and again, those indicators go up when it comes to women and girls, and specifically indigenous women and girls. So the core things that our people will stand up and literally lose their lives for: right of self-determination, collective rights, right to autonomy and self-government, and our rights to our lands and territories, which are all part of these core rights that we fight for. Several years ago, when the Special Rapporteur on the Rights of Indigenous Peoples, Dinah Shelton, came to Guatemala, she met with the Maya ancestral authorities throughout Guatemala as one of the government systems that she met, and actually my mom was part of that meeting, as she's part of the National Council of Elders. And so I share this photo because it shows you what our traditional government structures look like. What they're holding is the symbol of authority from the communities where they have been chosen through a process directly from communities selecting their leadership in a structure that has roots in ancestral systems. Yet, despite the fact that these are systems that are very, very old, the government of Guatemala does not recognize this. And so we are fighting for not only our recognition as indigenous peoples, but also the recognition for our traditional structures and political systems and decision-making process. But this isn't just in Guatemala. This is a fight that indigenous peoples are having, not just in the Americas, but globally. This is an elder, Tata Oscar, who's actually Maya mom, and we visited him in jail several years ago where he was thrown in there because of standing up for water rights in our territory. Since he was released, he was under house arrest. But these are our community members. These are our friends, our families. And these aren't abstract issues, but these are actually things that are occurring to our people. And then the most recent victims of conflicts and genocide, these are children and grandchildren that have recently died at the border. We have Felipe, who died in December, Maya Chu. We have Claudia, who's Maya mom, who is actually from the town next door to where I was born. She's the young woman in the middle. She was assassinated last year by Border Patrol, shot in the head. We still don't know who did it. And Jacqueline Cal, who is Maya Kikchi. All three of these young people, babies, are emblematic of the outcomes of unresolved tensions and conflicts in our territory, which is why people are being driven out. So whether it's situations around natural resources under extractive industry, or now because there's just no dignified living conditions, the face of the violations takes multiple shapes, and it doesn't have boundaries because they're existing all throughout the area. So, and I think I'm almost up for time here. So a lot of times our people, as indigenous peoples, the ones who are violating us are the ones that should be protecting our rights, and those are our governments. And government systems that were created over our people, over our lands, and over our bodies. And so in the last 35 years, and I know the speakers will go more into depth on this, but it's really been important to go to the international level because most of the time there are no domestic remedies, there are no outlets of justice for us in our countries because it is our countries, it is our governments who are the ones who are violating us. As was the case, for instance, in Guatemala in the 1980s when genocide occurred in tandem with the military, with government, and with death squads that were all mandated under the government. And so that's one of the reasons why there is such extreme lack of trust in these institutions. So recommendations. We recently had the American Declaration on the Rights of Indigenous Peoples, which I know will be talked on further in this panel. The American Declaration is actually a very important instrument for us, but one of the things that it does is it creates stronger language in terms of indigenous peoples and voluntary isolation. It also has stronger recommendations on the rights of women and children than the UN Declaration on the Rights of Indigenous Peoples, but a lot of us from community levels may not necessarily know that this declaration exists. So not only more awareness about it, but we need to start actually working as well on the practical implementation on the declaration, but not imposed from government side, but working directly with our people on what does that look like. So consultations, and I know that this has often been asked. We keep asking for governments to recognize our governments in our traditional structures so that we can participate at the OAS level, we can participate at the UN, but not as NGOs, not as civil society, but as governments. And so if this right of self-determination and sovereignty were recognized, it would help solve the litany of human rights violations that are occurring. And so this process still hasn't happened in terms of the recognition of our governments. And then, of course, the other spaces that a lot of our people use are what's available through the commission, thematic hearings, presenting specific cases, building up the facts, making sure that we have evidence that there are human rights violations that are occurring. Country reports, we really need to make sure that they include indigenous peoples, not just in specialized country reports about indigenous peoples, but across the board. Continue to have the country visits, such as has been done by Ms. Dinah Shelton, she came down, and the reports that came out after that, but also follow through on the recommendations that they make. Oftentimes those recommendations stay as recommendations, and so having political will from the states to actually implement some of those. And then continue to present the cases at the Inter-American Court. Again, that has to be exhausted at domestic side. But these are some of the outlets that our people use, again, because oftentimes we find that there are no systems of justice in our country and that impunity continues. And so that it concludes my presentation. Thank you.
We will hold the questions for discussion after the panelists have spoken. But our next panelist is actually Laura, who's going to summarize the statement of José Vicente Otero. It's important to understand that he's an indigenous activist from Colombia, and that he has been a journalist by background and is also working with our own anthropologist here, Joanne Rappaport. He's articulate, passionate, and has some very important up-to-date information, including just within the last week, an assassination in Colombia.
Quiero agradecer muy especial al Instituto de las Américas, a los diferentes a las diferentes instituciones y grupos de trabajo de Georgetown University y otras personas expertas en el tema indígena por traer al escenario este tema tan importante como son los retos legales y políticas actuales frente a los derechos de los pueblos indígenas de las Américas, para nosotros los pueblos indígenas de la Yayala. Yo voy a intervenir brevemente solamente para dejar en evidencia, dejar constancia de que en Colombia existe un despojo territorial y muerte para los pueblos indígenas que existimos desde tiempos milenarios en este territorio. En primera instancia, Colombia, como la mayoría de los países en las Américas, Colombia goza de lo que es el convenio 169 de la OIT, las recomendaciones de la OIT, y que posteriormente en la Constitución del 91, estas recomendaciones, este convenio prácticamente se convierte en una ley del Estado colombiano. Con ello, pues podríamos decir, si así se puede mencionar, de que nosotros gozamos del derecho a la autonomía y la autodeterminación, gozamos del derecho a los territorios, el derecho a unos derechos sociales y culturales, el derecho propio, el derecho a la participación, el derecho de los recursos naturales, al trabajo, a la salud, a la educación y a unos derechos políticos. Asimismo, podemos decir que Colombia goza de la Convención Americana de los Derechos Humanos y la Declaración de las Naciones Unidas sobre los derechos de los pueblos indígenas. Pero si revisamos en la práctica, en el territorio, realmente esto no es cierto. Esto es una gran mentira. Porque en Colombia no hay garantía, no hay aplicación efectiva de estos derechos. Así pues, es una gran preocupación la que tenemos los 106 pueblos existentes en Colombia sobre estos mecanismos, sobre estos tratados, sobre estos convenios internacionales y sobre todo la Constitución colombiana, en la cual está inmerso los derechos de los pueblos indígenas, pues realmente no hay absolutamente nada que garantice por lo menos la vida y la existencia de los pueblos. Así pues que en un auto que hizo la Corte Constitucional colombiana en el año 2004, que lo denominamos el auto 0004, prácticamente se evidencia de que los pueblos indígenas están en un grave riesgo de desaparición física y culturalmente. Este auto prácticamente es un llamado de atención que se hace al gobierno colombiano para que cumpla las exigencias, pero que tampoco se ha cumplido en su mayoría de la responsabilidad que se tiene. Se ha venido trabajando desde 2004, pero realmente no ha sido efectivo el cumplimiento en un 100%. Digamos que también hay una gran mentira, y es que ante la opinión pública nacional e internacional, el gobierno colombiano viene ratificando que en Colombia existe un posconflicto, que ya no tenemos ningún conflicto armado. Y la verdad es que aquí no existe ningún posconflicto, el conflicto se mantiene. El conflicto se mantiene porque yo puedo asegurarles a ustedes, y es lo que nosotros tenemos como estadísticas, es que la violencia sigue, la violencia permanece en nuestros territorios. No podemos desconocer que hay una gran relevancia de violación permanente, especialmente a los derechos indígenas relacionados con el derecho a la consulta, el derecho al consentimiento previo, libre e informado, al tema de tierras, territorios y recursos naturales. Recordemos que los pueblos indígenas no solamente estamos pensando en cuidar la tierra solamente para los pueblos indígenas, sino que es un compromiso con la humanidad. Y nosotros también podemos preguntarle a la humanidad cuál es lo recíproco, o sea, si nosotros ayudamos a mantener los ecosistemas, a mantener la biodiversidad, a mantener el agua, a mantener la flora, a mantener la fauna, pues cuál es el compromiso también que existe de la otra parte, porque por lo menos desde el Estado colombiano eso es imposible. Digamos que el gobierno colombiano no respeta ni garantiza los derechos humanos, por el contrario, ha puesto los territorios ancestrales en una compra y venta, en un marketing de mercado frente a las empresas multinacionales. Existe aquí muchas licencias, muchas concesiones mineras sobre todo, de capital nacional e internacional, en el cual no se ha consultado con los pueblos indígenas y que lo que ha traído es pobreza, lo que ha traído es muerte, lo que ha traído es desplazamientos y ha traído de una manera selectiva la persecución de los líderes y organizaciones indígenas que defendemos estos territorios. Estas licencias y concesiones mineras de exploración y explotación pues ha aumentado el paramilitarismo, se ha incrementado las leyes de despojo, o sea, como el Congreso de la República cada día saca normas, leyes que van en detrimento de la existencia de los pueblos, el desconocimiento a la ley originaria, a la autonomía, al territorio, a todas esas normatividades que tenemos como territorios y pueblos que manejamos una ley de origen. Entonces todo eso es una afectación de manera permanente. También hay una disputa territorial entre grupos armados, entre grupos de narcotraficantes, de diferentes sectores, de diferentes índoles, que están prácticamente disputándose este territorio que el gobierno no ha querido blindar a través del reconocimiento y aplicación efectiva de los derechos. Sobre todo hay una persecución ideológica también, son muchos los líderes que han asesinado, que han señalado y que siguen en una persecución constante por pertenecer y defender estos territorios. También hay unas muertes selectivas, masacres, ¿no?, que aumenta cada día las estadísticas y nos hace de que seamos el único país en América Latina que tengamos el alto índice de desplazamientos, muertes y persecuciones como movimientos originarios. Así pues, nosotros ya lo habíamos advertido hace algunos años, en 1994, habíamos dicho que el Tratado de Libre Comercio entre el gobierno de Colombia y los Estados Unidos era algo que era dañino, que era nocivo, y sobre todo cuando no hubo ninguna consulta con los pueblos indígenas sobre nuestra soberanía. También advertimos en varios escenarios, no solamente de Colombia, sino de todos los pueblos de la Yayala, de que el área de libre comercio para las Américas en el año 1994 también traería serias dificultades. El Plan Colombia, por ejemplo, nosotros habíamos advertido de que era un plan económico solamente para favorecer las grandes empresas que elaboran los químicos para la fumigación de los cultivos de coca, pero que realmente socialmente no condujo a nada, ni apoyó ni ayudó a ninguno de la sociedad rural en Colombia. También fuimos enfáticos en rechazar toda la instrumentalización de la integración de la infraestructura regional suramericana IRSA, el Plan Panamá-Puebla, por ejemplo. Todo eso nosotros dejamos como procedente de que no era más que una estrategia de entrar empresas multinacionales con el visto bueno de los gobiernos a acabar con lo poco y nada que nos queda en estos territorios indígenas. Así las cosas, pues, en Colombia la muerte permanece, la existencia de los pueblos indígenas cada día es más riesgosa. En un informe que hizo justamente la Defensoría del Pueblo, una institución que se encarga en Colombia de hacer seguimiento al tema de los derechos humanos, manifestaba que desde el 1 de enero del 2016 al 27 de febrero del 2018, en Colombia se presentaron 286 homicidios de personas, estos dedicados a la defensa de la comunidad o los derechos humanos. Y en lo que va de este año 2019 han sido asesinados 50 líderes sociales y defensores de derechos humanos. Pero también la Organización Indígena de Colombia, ONIC, en febrero de este año, advirtió a la Comisión Interamericana de Derechos Humanos que este año justamente de 146 asesinatos a líderes sociales en el año 2018, 58 eran líderes indígenas y afrodescendientes. Y que esto, en lo que va del 2019, han sido asesinados 13 indígenas. 9 han sido asesinados solamente en los últimos 2 meses en la gran movilización que hicimos en el suroccidente colombiano que denominamos La Minga. Allí fueron masacrados en una casa en La Delfina 9 personas con unos artefactos que fueron enviados, que fueron depositados allí para que fueran estallados estos indígenas. Otro murió en los enfrentamientos que hubo entre la fuerza pública y los pueblos indígenas en esta manifestación. Y también un indígena que acaba de asesinar hace 24 horas en el Chocó. Podríamos decir que del total de las agresiones contra líderes sociales en el año 2018, que fueron 347, 149 fueron indígenas y afrodescendientes. Así pues que los pueblos indígenas hemos vivido la mayor parte de este conflicto que no nos pertenece. Le hemos apostado definitivamente a la estrategia de la defensa para la paz. Nosotros consideramos de que ese proceso de paz, esos acuerdos, hay que blindarlos. En esa firma de ese proceso de paz está el capítulo étnico, el capítulo indígena, y que también está próximo a desaparecer. Si desaparece pues esta firma de tratado de paz, que prácticamente el gobierno actual quiere aniquilarla. Yo creo que también es importante dejar la evidencia de que el mecanismo de justicia especial para la paz está próximo a acabarse, porque también hay una política del Estado para acabar esta estrategia de judicializar y también de recibir a las personas que han cometido homicidios, errores frente a las masacres y asesinatos en Colombia, y que de alguna manera pues para el gobierno colombiano esto no es necesario. Podríamos decir que a pesar de las múltiples problemáticas que existen, también hay algunos mecanismos de resistencia. Nosotros le seguimos jugando a lo que son las vías de derecho. El único mecanismo que nos queda a nosotros son las movilizaciones, las marchas, y con ello hemos logrado de que el gobierno colombiano por lo menos haya escuchado a los pueblos indígenas, mas no de una manera definitiva. En los últimos 4 gobiernos existen más de 1.300 acuerdos incumplidos entre el Estado colombiano y los pueblos indígenas. También existe una política del gobierno que tiene que ver con todo este plan de desarrollo donde los pueblos indígenas no tienen participación equitativa ni son incluidos dentro de las políticas públicas del gobierno. También existe el fracking, que es una estrategia de explotación minera, el cual pues el gobierno lo ha implementado como una estrategia de desarrollo. También nos preocupa mucho lo que es la muerte de líderes sociales, y todo esto lo hemos recogido como unas incidencias no solamente del movimiento indígena, sino también del campesinado, de los afrodescendientes y otros sectores sociales, para que realmente pues se puedan cumplir estos mecanismos y que dejemos por lo menos a un lado las muertes de tantos comuneros, de tantas comuneras, porque realmente es muy triste ver cómo este país se desangra por falta de tener una coherencia en el respeto a la vida y a los derechos de los pueblos indígenas y de todos los colombianos. El discurso mediático es otro fenómeno que nos ha hecho mucho daño. Los medios de comunicación han tomado partido frente al gobierno, y los pueblos indígenas no somos más en el discurso mediático que personas que estamos involucrados con el terrorismo, que somos un peligro para el Estado, pero nunca se nos reconoce de que hay una deuda milenaria, de que hay una deuda de Estado en los gobiernos y la sociedad colombiana con los pueblos indígenas de Colombia. Las muertes son permanentes a periodistas. También quiero dejar sobre la mesa de que han asesinado a 4 periodistas indígenas. Hay conmigo varios periodistas indígenas amenazados, algunos con medidas cautelares por la Comisión Interamericana de Derechos Humanos. Así pues que Colombia infortunadamente necesita de que espacios como este, más allá de la reflexión, se hagan recomendaciones para que se pueda cumplir y que realmente podamos gozar de esos derechos tan importantes, tan especiales que nos han otorgado el Convenio 169, las Naciones Unidas, la OEA y la misma Constitución colombiana. Yo quisiera, para cerrar y agradecerles una vez más, decirles que no nos dejen solos, que nosotros necesitamos de la comunidad internacional, que necesitamos de personas, de instituciones que le hagan seguimiento a este plan de muerte que está haciendo el gobierno colombiano frente a los pueblos indígenas. Somos 106 pueblos únicamente que estamos haciendo resistencia y pervivencia para mantenernos en el espacio y tiempo, para seguir manteniendo la vida a cualquier costo, pero sobre todo también defendiendo la vida de todos ustedes. Muchas gracias.
One of the things that's been so important as we have a perspective on indigenous peoples and how we count them in various places is that different countries obviously have different statistics and different means of having an identity as indigenous peoples. So 106 peoples in Colombia, and we get a sense of what's happening to them real time. And for perspective, we have other very different numbers in other places, which we'll get to. Our next speaker, I'm delighted to say, is a Georgetown alum, can't resist mentioning that immediately, who has become the Associate Dean for International and Comparative Legal Studies at George Washington U Law School. She's also a former senior attorney at the Inter-American Commission on Human Rights. And so we're just delighted to have you back on campus. And her talk is called Contemporary Tendencies in the Development of Legal Standards Related to Indigenous Peoples in the Americas, Challenges and Advances. And I might add, she's originally from Puerto Rico.
Thank you so much. It's wonderful to be back at Georgetown, and I have to say, I'm very happy to see that Georgetown is organizing these kinds of events and working on such an important topic as Indigenous peoples and human rights. And thank you so much, Laura, for all the organization of this event. I wanted to give you and concentrate my remarks a little bit on the Inter-American System of Human Rights per se. I was very privileged to be able to work at the Inter-American Commission on Human Rights for more than a decade, and I was extremely lucky and very honored to be able to work a little bit with Indigenous peoples, with the issues, with the challenges, with the developments in international law. So I wanted to share with you a little bit of what I learned from that time, and a topic that I'm still studying now that I'm a full-time academic. And one thing that I want to start by sharing is that when you look at the Americas, we're thinking of not only Latin America and the Caribbean, but we're also thinking of the United States and Canada. The Americas covers 35 countries. So when we're thinking of the Inter-American System of Human Rights, we're thinking of this commission, we're thinking of this court, we're thinking of the Organization of American States, and we're actually thinking of 35 countries and indigenous peoples across the Americas, right? And another thing that I think is really interesting when you think of the Inter-American System of Human Rights is that the Americas has had a very important contribution in general to the development of what we understand today as international human rights law. And I think that's very palpable and cognizable when it comes to indigenous peoples. I think the contribution has been immense from indigenous peoples in shaping what we understand today as international human rights law, especially in the Inter-American System of Human Rights. The work of defining the obligations and the state obligations, as Juanita mentioned earlier, is usually the work of these international bodies. We have judges involved, we have commissioners involved, we have attorneys involved, but at the end of the day, the mobilization, the presence of indigenous peoples before the Inter-American System of Human Rights has really produced the standards that I'm about to discuss with you today. And one thing I want to note before I talk to you a little bit about this development of what we understand as legal obligations states have today is that the fact that you have an obligation codified in a treaty or in an American declaration or developed or interpreted in a commission ruling or in a judgment of the Inter-American Court does not mean that that gets properly implemented. We have massive and severe and profound enforcement problems in the Americas when it comes to international human rights commitments from states. And I have to say, indigenous peoples is one of the most alarming areas throughout the Americas when it comes to enforcement. There's a lot of work to do. So I want to start by saying that before I talk to you a little bit about what we understand today as indigenous people's rights within the Inter-American System of Human Rights, and maybe start carving a path forward for this as well. One thing that's really interesting when you look at the work of the Inter-American Commission and the Inter-American Court is that you have a set of rulings and judgments, especially those issued by the Inter-American Court of Human Rights, that have set this base or this background that we understand today as international human rights obligations when it comes to indigenous peoples. These are not the only bodies in the world that have pronounced on indigenous peoples, but these ones in particular have characterized themselves for being very detailed and for recognizing a lot of framework principles that we still use today when we discuss indigenous peoples, like self-determination, like this very important connection with territories and resources, right? And others that I'm about to discuss right now. I think when you think of the Inter-American system, it's difficult not to start with the judgments of the Inter-American Court of Human Rights. We have judgments from a range of countries, starting with Awastigni, with judgments related to Paraguay, with the judgments of Saramacca, with the judgments of Sarayaku. There's a lot of judgments that I could give you names today that have slowly set this line of standards that we have today recognized. This is not new, and this is not a voluntary set of obligations. These are real mandatory and binding obligations of states, especially when the Inter-American Court pronounces of them. So it's important also to clarify that in terms of international law. And most of these obligations and language by the Inter-American Court of Human Rights has been based on treaties as well, which is the primary source of international law. So I think it's very important to remark that from the beginning. And I think one of the most interesting things when you look at this line of judgments from the Inter-American Court and some rulings also from the Inter-American Commission on Human Rights, which have been important in this area, is that they have really defined some important obligations like the right to consultation, what we understand today as free, prior, and informed consent. And not only consultations as a process, but also the elements of that process. The fact that consultations should happen before the execution of any sort of investment, development, or tourism projects, as was discussed earlier. The fact that they should respect the governance structures of indigenous peoples. The fact that they should be appropriate culturally and traditionally and really respect the persons that are involved in these negotiations. They should be undertaken in good faith. Indigenous people should be able to consent, especially when or not consent, especially when we're dealing with large-scale projects. And there's many of us who think that they should always be able to not consent as well. So it really depends on the legal experts that you're consulting, but it's something that the tendency in international law is to actually provide for that opportunity to not consent. And I think one thing that's really interesting, aside from the connection to the territories, aside from consultation, is also this very broad conception of the right to life. We're not only talking about life or death anymore when it comes to right to life, we're talking about the right to a dignified life, and that means also the ability to carve your own life plan and to be able to live your life in a way that actually is in accordance with your worldview, right, and your traditions and your self-governance structures. And I think that's a very important and interesting legacy from the Inter-American Court. But I think one thing, when I think of the Inter-American Court of Human Rights and when I think of the Inter-American system that's really interesting, is not only the development that is very specific to indigenous peoples, but also the development concerning other very important rights that really affect indigenous peoples. And we've seen a lot of very important advances on this lately. The right to a healthy environment, for example. The fact that indigenous peoples tend to be very affected by environmental degradation, pollution, and many other areas like climate change and other environmental problems of our time. The reality is that the Inter-American Court of Human Rights issued an advisory opinion on the environment on human rights very recently that is really a landmark document when it comes to this broad nature of obligations states have, not only to prevent environmental degradation, but also to supervise a lot of activities that cause this degradation. I think also one thing that has been interesting about the Inter-American system is all the standards related to this duty to supervise private actor activity. The reality is that when we're thinking of international human rights law, we're usually thinking of state obligations, and we're thinking about this need to restrain state activity and state authority. I mean, this is how international human rights law first came into being. Now we're also talking about responsibilities over the acts of private actors, right? And I think the Inter-American system has been really interesting in developing a line of obligations for states, especially in the framework of what we know as due diligence and this duty to prevent, investigate, sanction, grant reparations, but also supervise private actor activity, which I think is very pertinent, especially when we're thinking of extractive industries and development projects and investment projects that can be very harmful. I wanted to say a few things about the challenges, because the challenges are many in the area of Indigenous peoples. And I have to say, one of the most important challenges are the lack of enforcement in general of the obligations that I just described. We have this beautiful language, and a lot of this language is very negotiated and fought. More often than not, when you're working as an insider in a place like the Inter-American Commission or the Inter-American Court of Human Rights, you see language like this, and this is the subject of a lot of discussions, a lot of negotiations. Sometimes it's a fight to get this language in, and this is kind of a win for the region, but this is language that's not been properly implemented. So we have a long way to go. And I think probably one of the most concerning challenges that I saw when I was at the Inter-American Commission is the dire situation of human rights defenders. I think you will probably hear this from every speaker. The reality is that we see killings on a daily basis of Indigenous peoples who are engaging in human rights defense, especially those engaging in defense related to the environment and their territories. Just this year, the Inter-American Commission has already issued a number of press releases highlighting the death of human rights defenders in Costa Rica and Honduras as well. And this doesn't even include the Colombia human rights defenders that were just mentioned and the ones that Juanita mentioned. I mean, that's how dire the situation is. When I was at the Inter-American Commission, it was one of the issues of most concern that we had when we were monitoring the situation of human rights in the region and the situation of Indigenous peoples. And I think also one issue that's really interesting that the Inter-American system has started to look at is, for example, the situation of Indigenous women, the situation of Indigenous older persons, the situation of Indigenous children, the combination of intersectionality issues with Indigenous peoples in general is a very interesting development to watch. There's a big issue with political will. And you learn that as an insider, and I think especially Indigenous peoples that work before the Inter-American system of human rights see this on a daily basis. One thing that I saw that was really interesting when I was an insider is I was able to attend some of the sessions of state negotiations related to the American Declaration on Indigenous Peoples. And one thing that really struck me was the fact that you had all these states representing the Americas, and they were trying to negotiate language or negotiate it down from the United Nations Declaration of Indigenous Peoples, a document that is really the product of consensus globally, a document that had incredible amounts of participation from Indigenous peoples globally. For me, that was very, very concerning to watch. The amount of negotiations that language included. It does include some good language, and it's important to use the American Declaration, but it could have been a broader document in many of the obligations. But it was a process where you saw a lot of issues of political will, and it's not a coincidence that it took 26 years to approve the American Declaration. Other instruments have taken much less time to adopt by the Inter-American system, so it also gives you an idea of where these issues are in the state conscious and the Americans yet. I think the issue of real and effective participation of Indigenous peoples is a huge one. What Juanita said is very, very important. I remember going to all these hearings for 13 years at the Inter-American System of Human Rights on so many issues. And like you said, I would love to see Indigenous peoples being able to sit as the government in these hearings. There's participation, but there's participation in some ways. It's not as effective as mandated by the state obligations, or at least a set of state obligations that we have accepted in this issue right now. And I think real and effective participation is really important, not only for issues directly connected with Indigenous peoples, but for issues of our time. like climate change, like violence, like human rights protection in general, and I really hope to see more of that. I really encourage you all to study the work of the Inter-American system. It's always good to connect it with what's happening universally, even though that really is broader in scope than what we're discussing today. But I think it's really interesting what's happening in terms of the theory, but I do think it's important to focus on the practice as well, and we do have many challenges when it comes to practice. Thank you so much for inviting me. It's wonderful to be here with you today.
Thank you. And everybody's doing a great job of staying on time. I'm delighted that these various frameworks are coming forward. We have a kind of picture of the initial Indigenous Rights IOL 169 from the 50s, and then when it was revised later by 90s, so we have the UN Declaration of Human Rights, and now an American Declaration that is in some ways an improvement, in other ways watered down. I get the impression that we may have a little bit of tension here, particularly as it's a document that had 26 years in negotiation, which is amazing. What I'd like to do now is move on to our next distinguished speaker. We have Leonardo Crippa, and he is a senior attorney at the Indian Law Resource Center. We're delighted to welcome him here. He's got legal degrees, his first one's from Argentina. As in all of these cases, you've got more bio in front of you, so I'm not going to read everything, but just tell you that he's going to talk about challenges in the protection of Indigenous peoples' rights.
Thank you. Thank you for Georgetown, the different centers and institutes for organizing this particular event. This is the first time I have the chance to speak about the work that we do at the Indian Law Resource Center. And so I'm very much surprised about the different institutions that are supporting this event, and many of them with a focus on Indigenous issues. I am going to be very brief, and I'm going to build from the previous speakers. I'm glad that Rosa was able to explain the Inter-American system very briefly, and so I don't have to spend time on that. And I think the reports and the picture that was drawn by Juanita's presentation and José are very self-explanatory of the struggles that indigenous peoples and leaders are facing throughout the Americas. I made several notes about several cases, and then I decided to only talk about a few of them. But I'm going to try to provide you an overview of where I see challenges in the protection of the human rights of indigenous peoples, focusing only in everything related to collective rights, such as self-determination, self-government, full collective ownership of land and natural resources. I will also talk a little bit about the law of responsibility, something that Rosa was talking about too. And then I think I would like to say something very briefly about the American Declaration on the Rights of Indigenous Peoples, something that has been mentioned by the previous speakers. As you may remember from the previous speakers, indigenous peoples have a special attachment to the land, and they are distinct political and political entities in the society of the nation states, and as a result, because of that very strong connection to the land, the territories and resources, and that self-government structure, they are entitled to the right of self-determination. Self-determination and the collective ownership of lands are key collective rights for the physical, political, and cultural survival of indigenous peoples as such. However, in the Inter-American system, you will not find, for example, a treaty, human rights treaty, laying out the different elements of the right of self-determination or the right of self-government. As you may have heard from Rosa, especially, the Inter-American system relies on one particular treaty, the American Convention on Human Rights, and on one key responsibility, which is the individual state responsibility. But this particular treaty, for example, falls short in explicitly recognizing the right of self-determination. And when cases are brought to the Inter-American system, especially the Commission, there is a tendency to try to fill that gap by looking into rules of interpretation. For example, Article 29, that suggests that in applying the pro homine principle, you have to look to the highest standard or make a progressive interpretation of the rules of the treaty in order to be able to provide effective protection to the victim. And that is resorting to rules of interpretation because of the main human rights treaty, while there are other sources of law. For example, for the right of self-determination, you have Common Article 1 of the UN Covenants on Civil and Political Rights, the UN Covenant on Economic, Social and Cultural Rights, and many UN General Assembly resolutions that provide for the right of self-determination. More recently, in 2007, the UN adopted the United Nations Declaration on the Rights of Indigenous Peoples, and this is the first instrument that lays out the right of self-determination for indigenous peoples. Here in the OAS, we have another declaration, which is the American Declaration on the Rights of Indigenous Peoples. The very first articles also recognize explicitly this right. However, if you read the decisions from the Commission and the Court, you see this overwhelming use to rules of interpretation for the purpose of filling the gap and trying to base our interpretation on the facts of the case and on the rights that are recognized in the American Convention on Human Rights. And so we have a problem there. It is very important because this very right of self-determination is a right that every people is entitled when it is subject to subjugation of the colonial power. And that's been the case in many situations in the Americas. One very recently development is what happened, for example, to the Rapa Nui people in Easter Island in the Pacific Ocean, where Chile exercises some sovereignty over this island. They have been subject to subjugation for over 60, 90 years. They've been put in a concentration camp called Hangaroa. They haven't been recognized as citizens of Chile, and they basically leased the land to a British sheep company so that they can bring their animals and live there. And until 1960, they were for the first time recognized as citizens of Chile. And in the meantime, you can imagine all the displacement that the different clans of the Rapa Nui people suffered during that time. Of course, it is not a well-known story, but very recently, in 2010, there was another exercise of power over the Rapa Nui people because many of the clans decided to go back to their traditional lands. We're talking about around 36 traditional clans, and most of them decided to go back. And when they went back, they found government offices, private companies, headquarters, and so forth. And it implied the militarization of the island for the purpose of reseeking power of Chile over the Rapa Nui people. When the issue was brought to the Inter-American Commission on Human Rights, I don't think the Commission knew about the Rapa Nui people. I was the lawyer representing them. And it took several months to be able to get a decision from the Commission to protect the people of Rapa Nui. And when the decision was made, already one of the very first evictions took place. And as a result, you can see photos in the internet of people who lost their eyes, women who have been shot, kids that have been detained, several criminal cases built upon by the government against the spokespersons of each of the clans. And so sometimes there are issues that are so controversial in a country that requires a very an approach to the issue that has to be different from the previous ones. Especially when international law has evolved so much, and when the countries at stake have provided consent to the new international law recognizing the rights of indigenous peoples. I have more to say about other cases, but something that I also wanted to mention is about the law of responsibility. International human rights law, as you may know, emerged in the 1940s as a way for the international community to solve the problems that are a consequence of many world wars. And as a result, not only human rights law emerged, but also, especially here in Washington, the idea of rebuilding the economy of the countries that were involved in the world wars. And so you have the 1948 declarations of human rights from the United Nations, from the OAS. At the same time, here in Washington, you have the Washington Consensus. Especially the US government, with many developed nations, decided to create international financial institutions for the purpose of rebuilding the economy of the states. And as a result, everything has been developed for the purpose of protecting the right of those who are subject to the jurisdiction of one particular state. And so the responsibility is attributed only to that particular state. You have heard from the previous speakers, especially from Juanita and José, that there are, for example, corporate abuses in Guatemala and Colombia because of their interest in indigenous people's natural resources or lands. You have also heard about massacres being perpetrated by governments. And I can give you a couple of examples where both actions are related to, for example, a project funded by an international financial institutions. And because of the law responsibility today, we as attorneys have only the chance to resort to the inter-American human rights system or to the UN human rights system for the purpose of seeking the responsibility of one particular state. In the case of Guatemala, for example, there is a hydroelectric project called Jigsaw that in the 80s was funded both by the World Bank and the Inter-American Development Bank, and resulted in the massacres of many Achi communities. And that happened during the internal armed conflict that Juanita was referring to. When the issue was brought to the Inter-American Commission and then the court, we were only, or the attorneys who were handling that case, were able to seek the responsibility of Guatemala when all the funding was coming for an intergovernmental organizations. And why I'm mentioning this? Because there is a gap in international law, especially in the field of human rights. Nowadays, you can only seek the responsibility of one individual state. In most cases, it's the weakest state. It's easy to win a case against a particular state because of human rights violation against indigenous peoples. But you are not, because of the rules of responsibility, in a position to sue either the corporation or the intergovernmental organization. In this particular examples that I was mentioning, for example, the World Bank or the Inter-American Development Bank. And you can read the Rio Negro decision from the Inter-American Court about the massacre of one community. The context is that Jigsaw project funded by this international financial institution. That is a big challenge for the protection of indigenous peoples, and it is a big challenge for the development of law in general. At the United Nations level, the International Law Commission, which is a body of independent experts tasked with putting in a draft treaty the rules or codifying the rules of customary international law, has developed what is called the draft articles of the responsibility of intergovernmental organizations, precisely to fill this gap in the law. Of course, there was no consensus in the General Assembly, and as a result, it was not adopted. And nowadays, we continue to have this human rights system relying on the responsibility of one particular state. At the United Nations level too, back in the 90s, in the late 80s, there was this attempt to create a treaty that will address directly the responsibility of private sector actors, especially corporations. There was no consensus. As you may know, the General Assembly, and during that time the Human Rights Commission, operate on the basis of consensus of states. There was no consensus to go forward with that idea. About 10 or 15 years later, the United Nations General Assembly, especially the General Secretariat, appointed Professor Ruggie, a professor from Harvard, to develop a soft law about the issue of business and human rights. And as you may know, the United Nations adopted the guiding principles on business and human rights, which only provides for actions that can take states to address abuses perpetrated by corporations, but it does not extend the responsibility under international law to the corporations. Nowadays, in the last 3 years, the United Nations is also resorting to another initiative, which is being led by the mission of Ecuador to the UN, which is the Intergovernmental Working Group on Business and Human Rights, which is tasked to developing a treaty precisely on the issue of business and human rights. Again, no consensus toward extending the responsibility beyond states, but still a more serious effort to develop the law in a binding way in a treaty. There is a zero draft that was made available last year. Comments are being received by whoever is interested in participating in this treaty-making process. While we see these developments at the United Nations, we don't see something similar at the OAS. We only rely on the Commission and the Court adjudicating over very particular cases, state responsibility, but there is no leadership from any OAS member states to go for a process that will address these gaps in international law. Standard setting. Something that has been mentioned here, and I think I'm going to close with this, is the fact that developing international legal standards on the right of indigenous peoples is very challenging, because it implies a very complex lawmaking process and educational process, where you will find most of the time, because of the pressure that has been put in international organizations, grassroots leaders, human rights attorneys, and governments that are making up organizations such as the United Nations or the OAS to negotiate vis-a-vis, in these particular cases, a declaration for the purpose of having an organization declaration on the right of indigenous peoples. And it takes time. But the importance of this long lawmaking process is that in the meantime, you have different human rights bodies making use of the legal standards that are being developed. For example, in 2001, the Inter-American Commission on Human Rights decided the Mary and Caridan case against the United States, and it looked into the draft American Declaration on the Right of Indigenous Peoples that was being negotiated during that time. And there are other cases like that where the Commission resorted to developing principles of law that members of the Organization of American States were developing vis-a-vis indigenous peoples. Now, the OAS General Assembly has adopted back in 2016 the American Declaration on the Right of Indigenous Peoples. It's the first regional instrument about this particular set of rights. It recognizes collective rights, also individual rights, and as Juanita mentioned, there are some regional particularities of indigenous peoples that have been particularly addressed that you will not find in the United Nations Declaration on the Right of indigenous peoples, such as, for example, indigenous peoples living in voluntary isolation, there is very important provisions about indigenous family. The fact that adoptions cannot be made without prioritizing the fact that an indigenous kid belongs to an indigenous family, and as a result there are cultural differences that have to be addressed. The Convention on the Rights of the Child has no provision about it, and that's a UN instrument. There is a provision about protecting indigenous peoples during internal armed conflict because of the situation in Colombia. There is a recognition of the contribution of indigenous peoples to peace in countries. That is, for example, the Indigenous Guard in Colombia. This is an indigenous people's self-developed security structure for the purpose of protecting the communities during the internal armed conflict. The authority of that security guard or force is being recognized in the American Declaration, and I can go on for the entire day. Look at that declaration. A year later, we had a very strong discussion with the OAS member states for the purpose of starting to discuss a way to make these rights be realized by the organization and by its member states. And as a result, with the leadership of the mission of Mexico to the OAS, we were able to develop a plan of action. That plan of action sets different measures that both the OAS as an organization and member states have to take for the purpose of realizing the rights that are recognized in that declaration. And I want to mention that there are two challenges there that are going to change the way the OAS deals with indigenous peoples.
I think we should probably wind up, though.
Okay, just
so
two
those two challenges,
Yeah.
and we'll pass it on.
Yeah, one is a monitoring body. That is an organ within the OAS structure that will be tasked with supervising compliance with the American Declaration on the Rights of Indigenous Peoples. There are other declarations that have monitoring bodies too, so the question of whether or not this is not a treaty and it's not binding is a silly question right now. The second one is the participation in OAS activities by indigenous governments. Right now, the rules of participation in OAS activities is focused on indigenous peoples as civil society organizations. But as you have heard from the previous speakers, there is quite a difference between these entities. And as a result, these two topics are part of the plan of action and have to be discussed by the OAS.
That's a perfect theme that has been coming up several times, so a good way to end. Thank you. Our next speaker is going to be able to broaden this into further international context. Ralph Bunch comes to us from a very distinguished organization. He is General Secretary of the Unrepresented Nations and Peoples Organization. I can't think of a better person to have on this panel and to have us wind out the panel. And he's speaking on reflections on the experience of unrepresented nations and peoples organization. So from your base in the wider scenario, you've had enormous experience as a lawyer and as an advisor to governments, businesses, grassroots movements. So welcome. Thank you.
Thank you. Thank you very much for having me and for Laura for pointing this out and having me come. It's fortuitous that I'm here because I'm here for a week with a community of Hmong people from Laos. And I'm going around the US Congress and other institutions to try and raise awareness of attacks that are happening against a small community living in a special zone set aside for them in a very remote area of Laos that is currently a very useful place for mining. Lots of gold that's there. And their territory is being encroached on, this special zone is being encroached on increasingly, and they're being attacked in order to clear them from the land for mining purposes. So I'm running around with lots of horrible pictures of women and children and others who've been murdered, who've been injured by the Laotian military, with the support of either or both the Vietnamese and the Chinese military forces. Now, I raise it because I'm always very boring when I come to these meetings, and I'm always the guy who says, what you're experiencing here is being experienced everywhere else. It's the role of the organization, it's what we're there for, and it's just something that is consistently true. I mean, you can hear from the story that I talked about just now, reflections and echoes of what we just heard about elsewhere. You see it across the world and across the membership of our organization. You see it also in things like you're reading a lot about in the press these days, the forced assimilation of the people in Xinjiang, the Uyghur people, and the Tibetan people in China. And there's echoes of that in the language that you hear from President Bolsonaro in Brazil. Real frightening echoes. So I want to just talk a little bit about the sort of similarities and I guess a little bit the differences and reflect on what we're seeing elsewhere, specifically as it relates to the inter-American system. But I just say that just to highlight also it's not just about the system that I'm talking about, but it's about the people. The situation that's happening around the world is very, very, very similar. And it's similar also to people who fall outside of the definition of indigenous people. So we at the Unrepresented Nations and Peoples Organization, we're here for people who are unrepresented in some ways. I think one of the best ways of explaining the organization is the saying that they like very much in Brussels, which is, if you're not at the table, you're on the menu. And it's true of peoples everywhere, whether they're indigenous, minorities or not. It's true of one of our members, which is the people of the District of Columbia. The government of the District of Columbia is a member of my organization. If you are a member of the District of Columbia, you do not have a seat at that federal table. And you see it everywhere. So I wanted to just raise that point and just to say that there are reflections around the peoples too that you can talk about, that there are similarities everywhere about those things. But specifically I want to talk about the similarities, about what's happening and the lessons that you can learn with the inter-American system and other systems. And I want to say something positive at the beginning, because too often in the international human rights community, we're very good at raising the criticisms and not very good at celebrating the successes. And that is, I would say, that with the inter-American system, you have something here that is quite phenomenal. It's quite progressive and amazing in a comparative context. Yes, it has significant challenges, and we've heard about those challenges, but when I look at the functioning of the European Convention of Human Rights, when I look at the functioning of the various bodies in Africa, whether it's the Southern African Development Community or the African Union, you can see real positive things here. Positive in terms of the court and the way in which the court is moving the definitions. We heard about that earlier. Really moving these definitions in positive ways in an environment where it's almost impossible to get international consensus on rights like the right to self-determination, to get those standard settings. The court moving those definitions is amazing. And the participation levels. I agree with you. I heard a lot about the participation challenges that are here at the inter-American system, but the participation levels are better than I see elsewhere. The fact that you're having the conversation about wanting a seat at the table, not as civil society, but as indigenous governments, is an amazing place to be in comparison to where other peoples are elsewhere. So I want to say those things because it's really important that we remember them. We always forget those things. But now just to go through the challenges a little bit, because you hear about them with the court and with participation. I want to talk about this sort of globally, talk about some of the things that to be able to be concerned about and aware of, but also some of the positive things that are happening elsewhere. So on the court, I think the big challenge that you're seeing with the court, that you see a lot in Europe, there are twofold challenges and they're interrelated. One is a backlash against the court. It's very progressive, it's moving things very progressively in ways that I think we all want it to move things, but that is causing a backlash, particularly as it relates to countries that have the rise of populist governments. And you can see that in Europe, you can see that in sub-Saharan Africa for sure, with the Southern African Development Community, which basically had to wipe out the court because of the judgment that people didn't like around land rights. You can see it in the European Union with countries wanting to withdraw from the Council of Europe, like Britain, wanting to withdraw from the Council of Europe as a result of the judgments of the European Court of Human Rights. And you can see it here. It's been a persistent problem in the inter-American system, threats to or actual withdrawals. As well as something that you see a lot in Europe, which is court packing, constitutional courts being packed and being very pro or very anti the European, the international mechanism that's being enforced, the inter-American mechanism here in Europe, the European Convention on Human Rights, and setting out judgments that are effectively excluding the jurisprudence of the court, one way or the other, from its applicability at the national level. It's very concerning, and it's linked also to this question of enforceability. So everywhere, that's the issue. In Europe, that's really the issue. Judgments that are not implemented, judgments of the courts that come out that are very strong, that governments, that courts are refusing to implement. And you see it throughout the inter-American system. It's a big problem. So those similarities really do exist on those things. So it's the populism, the sort of backlash, the fighting against it, and the other things. And I just have some reflections on what's going on in Europe about that stuff that I think is quite useful. So in one thing that's happening in Europe, there's a renewed focus on trying to use the mechanisms that exist for implementation to get better implementation of the judgments of the courts. So the society groups are creating networks that aim to sort of press as hard as they can at the national level and at the international level for greater implementation of those judgments. And one thing that is happening more and more because of the European Union and the benefits of engagement with the European Union that exist are increased efforts to highlight that the failure to implement judgments of the European Court present fundamental rule of law problems with the countries, within those countries. Because the convention is part of the constitutional order of those countries, and it's very similar here. And there's a movement to sort of start tying aid and trade a little bit more to this rule of law crisis that's happening in terms of implementation, and I think it's starting to help move things forward, greater focus on sort of ensuring implementation and following it up. It's happening and it's making a change. So I think there's a lesson that can be learned here on that. It's important also because because without it, there's become a bit of ennui, or whatever the word might be, actually, a bit of dissatisfaction with the system as a general matter. And that's very dangerous because it plays into the hands of the populist governments that want to withdraw from these regional bodies. So that's on the court. On participation, I just want to say again how it is a very participatory system here compared to others. And I want to talk about a report that we're about to issue on the United Nations mechanisms, because what's happening at the UN level now is quite frightening, and I think it's something to be aware of and concerned about here. Although I don't know if it's happening here, I don't think it is in the same way, other than there is obviously the ongoing problem with human rights defenders, which I'll get at. There have been some very hard-won gains at the UN system. In 2000, we have the Permanent Forum on Indigenous Issues, which gives a forum for Indigenous people to speak about their issues at the United Nations. 2007, you have a minority forum that's created that gives minorities greater voice at the United Nations. Really hard-won, long fights to get these things that are really important to get people at the table, even if they don't have the equal level of nation states. But there's been a backlash, and it's been very, very aggressive. As the US is sort of pulling out a little bit of its focus, a lot of its focus at the United Nations, the European Union is divided and is not very good taking a lead in protecting the rights of these independent voices of minorities and indigenous people in particular. China and others have started to move the system in a way that sidelines human rights and sidelines the voices of others. So participation, getting ECOSOC status, which allows you to participate, is getting harder and harder. It's making it more and more difficult to get ECOSOC status. My organization has never had it. It's always been impossible for us because of who our members are. But other organizations that you would typically think would not be that concerning, they're talking about human rights of minority or indigenous communities, are finding it much harder to get ECOSOC status. When people get into the United Nations and start working there and talking there, their voices are either being drowned out by gongos of government, non-governmental organizations, or they're being, and they are being followed, intimidated, bullied in the room, pictures taken of them, and then most crucially, most disturbingly, reprisals are taken when they get home, or if they're not home and they're in exile, against their family members. And it's a very consistent trend, something that I'm very concerned about. And I'm not sure the extent to which, I'd actually be interested to hear the extent to which this is existing in the inter-American system, albeit that there is this issue about human rights defenders. But I say it as a warning because the playbook has been established now on how to drown out voices internationally. These regional institutions are incredibly important. They exist, actually, historically. There's a great book I recommend everyone looking into by an academic in Chicago called Adam Getachew, I said that wrong, I'm sure, who tracks the history of the right to self-determination and the creation of multilateral and regional institutions, and talks about the rise of self-determination movements and nationalism in the context of a need for internationalism, for regionalism, to protect against imperial domination. And you have to remember that when you think about these institutions, these regional institutions, the greater unity that we have regionally has historically been designed to prevent against sort of big power domination. And unfortunately now we're seeing the playbook has been sort of set that is now making these international institutions not work. And it's very important that we try to make them work, because without them, people are voiceless, and you can hear it here in the conversations we've had. The inter-American system is all we've got to speak. And so for us, we're at this really scary, critical moment. Populism is in the West, it's just everywhere. People are scared of international institutions, and then repressive governments are turning those international institutions into vehicles for repression. And I'm worried that this might happen here in the American system. That's what I have to say.
Thank you so much. You raised some very serious issues, everyone has, and I think the audience has been patient enough that rather than taking a moderator prerogative and asking the first question, I wanted to go straight to the audience. I can fill in gaps if need be, but I suspect that we've got a lot on our plate and not a lot of time for discussion. So let us see if you've got anyone here who would like to address any specific speaker or a more general question. Anyone?
I have a question for Mr. Crippa, or perhaps the whole panel. You talked about holding things like corporations accountable for their actions, especially within indigenous communities. Has there been any attempt at the inter-American level at 35 states that we were talking about? Has there been any attempt there to institute something like a rights of nature and earth jurisprudence, however you'd call it? I know that probably about a decade ago, maybe Bolivia or Ecuador incorporated the rights of nature within their constitution, and so that gives the people a mechanism to protect against pollution and infringements on the land. Has there been any attempt to try to broaden that out to the greater continent?
Should I respond?
Anyone can respond as you wish.
Do you wait for more questions, or we go ahead and respond?
Go ahead.
Okay. The Commission, especially the rapporteurship on economic, social, cultural, and environmental rights, has been recently created and Soledad Muñoz, Garcia Muñoz is the rapporteur who has taken the lead in developing guidelines on the issue of business and human rights. And I believe that we'll have a lot of approach to the question of environmental protection. Something that I didn't mention, and I think it's important too, is that global and regional development banks have developed environmental and social safeguard policies, which are meant to guide the borrowers and the banks in taking measures for the purpose of preventing harm to the environment and the people. So usually there are a set of 10 policies in each of these institutions. The Inter-American Development Bank in particular has adopted in 2006 for the very first time an operational policy on indigenous peoples. The World Bank and the International Finance Corporations did so back in 1981-82. But I'm mentioning this because these banks provide funding not only to developing countries, but also corporations. And so, for example, the IFC, the International Finance Corporation, the IFC, the private sector arm of the World Bank Group, has a set of policies. There is one umbrella policy called the Environmental Assessment Performance Standard, and that is supposed to provide guidance to clients of the IFC, which are companies operating in the developing world, how they can assess environmental impacts in their operations, especially when there is a likelihood of or potential harm to the environment. The Inter-American Development Bank in the last 3 years decided to open up a new branch or a new institution, which is called today the Inter-American Development Bank Invest, the IDB Invest, which is meant to provide only funding to private sector companies. Instead of developing a set of 10 safeguard policies like the other banks, the IDB Invest decided to develop an environmental and social assessment that is supposed to cover what the other 9 policies do in practice, and nowadays is reviewing this for the purpose of actually adopting the IFC performance standards. And so there is a developing area of policies that are also meant to protect the environment, apart from typical human rights law or typical environmental law.
No? Anyone else want to address that?
I think it's important to acknowledge that these policies are being developed, but you think of the practical implication and who holds that process accountable. For instance, an example with the Marlin mine, which is in Guatemala and one of the largest gold open pit mines that was actually in our territory, had funding through, I think it was the IFC, and it had been touted as a model of how to do development right. And so now that the project has been closed and the news clippings just came out last week, people are still asking, what about our water? You know, what about the pollution that was left since the closing of the mine? And so this is despite the fact that Guatemala has been a champion, quote unquote, at the international level to advance indigenous people's human rights within the UN spaces, within the OAS, has friendly member states, has ratified everything, has very lovely sounding articles in our Constitution, has a mandate from the peace accords and the identity on indigenous peoples. But it goes back to how does this actually trickle down? When do we get to participate on what's happening on our lands and territories? And also, I think if you look at like Bolivia, it did become part of its constitution, but you know, that hasn't really seemed to materialize so much either. One of the things that I think is important is just from my observations, for instance, from FPIC, Free, Prior, and Informed Consent, when that became kind of the trend and the standard that environmental organizations kept talking about, the substantive rights of self-determination and autonomy and self-government got lost in the wave of everybody pushing free, prior, and informed consent. And so I think it's very important that if these other principles on the rights of nature come through, that also the rights for indigenous peoples are not separate. Nature isn't separate from us as human beings. And so that's also something that needs to be very careful in that it doesn't become something that environmental organizations or human rights organizations that are allies in trying to do the right thing but causing confusion in the process.
More questions?
Yes.
In 2017 in Canada, where I'm from, there was a landmark case regarding the Phoenix Mine in McGhee territory in Guatemala. And essentially, a judge agreed to hear a case and rejected HUD-Bay's attempt to get it thrown out of court, and this was related to human rights violations at that mine site. That then opens up at least a brush with accountability and maybe a path forward, at least in Canadian courts in the future. It's a landmark case. But this ties back to a challenge that I don't think was discussed very much so far, although thank you all so much, fantastic panel. But one question I did have, one of the only reasons that case was able to go through was because the plaintiffs were able to secure funding and the means to prosecute that case for 8 years, I think is how long it took to get to that point in the appeals process, and it's still ongoing. So, I mean, the most determined and most resilient resistance out there is still going to bump into significant financial barriers and time barriers. What resources are out there now? Is there any development in that particular realm? I'm only curious.
Happy to talk to that. So in a prior life, that's what I used to do. So I was a plaintiff's lawyer, bringing business and human rights cases. Primarily, we started here with the Alien Tort Statute, which was the U.S. version of this, this universal jurisdiction type work. That has now been greatly restricted in its applicability to corporations in the United States, and so that sort of model is not quite so there anymore. But in the firm that I was in, models have been created to finance this kind of litigation globally. So the firm is continuing to bring cases in South Africa, it brings cases in the United Kingdom, which is a good, for now until Brexit, a very good jurisdictional place because the EU has a specific jurisdictional statute that allows this stuff to grab actions that happen elsewhere if a company has not just its headquarters but has any office. So it's a good jurisdiction for that. And elsewhere. The challenges are always length of time. So just the challenges with the sort of exercising of this kind of universal jurisdiction, as it were, over business and human rights cases. It's always very timely. It takes a lot of time. It raises foreign policy concerns, and that's one of the things that ends up taking too much time. This was the experience here in the United States, where there's always some moment where the U.S. federal government could intervene to talk about the sort of foreign policy implications of these cases, and that would slow cases down considerably, and then endless appeals, all of those things, and leave aside sort of the class, we have class actions here, but the sort of what is the class you're representing is the issue. So ultimately, those cases are just long and drawn out, they're spotty. Yes, there might be an avenue through Canada, but that will be only a piecemeal answer. Ultimately, that's not going to be the answer. The national courts have to deal with this stuff. So it's not a sort of long-term solution. So that's just the general criticism. On the funding, yes. So there are claims purchases that run around and buy up claims. Typically more available, frankly, in the context of things like antitrust, where claims purchasing will have good profits, but there are crowdfunding mechanisms that can exist also to sort of help buy up claims and to aggregate claims. Claimants firms exist, like the one that I worked for, that fund litigation elsewhere as part of their strategy. So they take the proceeds and profits from more high profit ventures and do this stuff on the side, so that exists quite a lot. And there are different types of funding mechanisms. It depends where you are, because there are questions about, if you're in the United Kingdom, for example, there's lots of risks, because there's the costs, if you lose, can be attributed to the winning party. That doesn't exist in the United States. So there are sort of different types of litigation insurance products that are being developed, that have been developed, that allow sort of things like contingent insurance premiums. So you pay insurance premiums when you win, but they cover you when you lose. Those kinds of things exist. So yes, those mechanisms exist. We used to do a lot of work with McGhee and all of that, but I think ultimately it's not a long-term solution to a problem. And just like, I would say, bringing cases to, and this is what I think was the most effective ones of those, just like bringing cases to the Inter-American system or the European Court of Human Rights, in part, you can never use that as the end. The case isn't the end, you're not going to get redress, you're not going to get what you want, the case won't be enforced, or whatever it might be, but it's typically best when it's part of a grassroots strategy that is you're using it for communications purposes to get leverage from the national government as well. And when you do that, it's quite effective. Anyway, I went all over the shop on that one, but you raised it.
I'll cover it. Thank you.
Yeah.
Well, great answer. You had a question?
Yeah, well, thank you so much to all of you. I wanted to hear a little bit more about the monitoring body, Leo, that you mentioned regarding the American Declaration. I'm aware that the plan of action has a 4-year time span. We're about to be right in the middle, and I know the OIS is a little slow sometimes.
Yeah.
So
the idea behind the monitoring body is to have precisely that, a body that will be tasked with receiving reports concerning implementation of the declaration by the OAS member states, and that indigenous peoples will find in that body a way to report violations and seek reports and some remedial actions. The plan of action, one of the actions that it suggests is that the OAS develop such a body. That discussion didn't take place yet. Last year, the first Inter-American Week, the first time the OAS has sort of an annual gathering to discuss indigenous issues happened last year, and that's a result of the plan of action. But the topic, the focus was, I believe it was indigenous languages. We are trying to push the OAS member states to agree to start having a discussion on the implementation body, and the idea is to have, prior the Inter-American Week, a 2-day conference outside of Washington, D.C., where indigenous peoples and OAS member states can meet to discuss the elements of such a body. We have been developing memorandums about what the mandate would be, the composition of such a body, and the different set of actions that such a body can take based on the experience that we have in creating a similar body at the United Nations based on the United Nations Declaration on the Right of Indigenous Peoples. As you may know, the expert mechanism on the right of indigenous peoples was created right after the UN Declaration was adopted. And then a World Conference took place for the purpose of making that body more efficient, more effective, more open, and so forth. And that discussion is, we hope, can start to take place this year at the OAS.
And it is the Year of Indigenous Languages at the UN with an upcoming forum.
But I have to say everything in the OAS has been about, as you can imagine, Venezuela, Nicaragua, and so many issues have not been able to be addressed by the agencies.
Solo quiero agregar un poco y una pregunta sobre el sistema de la Declaración de los Pueblos Originarios en 1993, porque yo estuve en Austria.
Just wanted to add a little bit and ask about the Declaration of Original Peoples that stemmed from 1993, because I was a part of that convening.
Es ridículo una negociación sobre nosotros como pueblos originarios del mundo. Por fin nos dan un reconocimiento, pero nunca nos han dado esa participación para hablar sobre nosotros, sobre la madre tierra y sobre los efectos que estamos recibiendo en estos tiempos.
It's ridiculous that these negotiations take place regarding us as original peoples, but yet we continue to be left out of the conversations regarding Mother Nature and our rights in protecting our natural environment.
Entonces ahora, ¿cómo ven ustedes, como ustedes tienen una capacidad, tienen esos derechos de estar en una mesa de negociaciones, cómo va el sistema hacia la humanidad?
And you that have access to these spaces and you're present at these tables, whereas we're not, how do you see these spaces actually doing something to benefit us original peoples?
Porque durante estos tiempos que se ha hecho esa declaración, el caso de Guatemala cada vez se ha empeorado. No solo de Guatemala, pero también que todos los pueblos que participamos en ese tiempo nunca hemos escuchado nuestras peticiones, las resoluciones completas que nosotros necesitamos.
And while the negotiations were taking place for this declaration, the situation in Guatemala has continuously gotten worse, and we're not hearing of these resolutions and these processes that are happening.
Entonces quiero saber de ustedes, cómo ustedes siempre están, y nosotros somos el contexto y ustedes tal vez son el texto que sí manejan los documentos. Esa es una pregunta que haría a ustedes.
So, essentially, how do you see this? We are the context, and essentially you are the text writers.
Yes, I think I get answer.
Muchas gracias por esa pregunta.
Right, it's crucial.
Y yo creo que es una pregunta, le voy a dar la contestación de una persona que estuvo adentro y una persona que está afuera ahora. Lo que yo vi adentro y lo que veo de afuera. No es un sistema perfecto. O sea, cuando uno mira el trabajo de la Comisión Interamericana, cuando uno mira el trabajo de la Corte Interamericana, estos son sistemas regionales, es un sistema regional que a pesar de que es fuerte, es un sistema imperfecto. Y cuando yo pienso en el tema de participación, yo creo que hay mucho que todavía hay que hacer. O sea, yo vi a muchos pueblos indígenas venir y reclamar ante la CBH y ante la Corte Interamericana y obtener muchos logros.
And can you give a translation?
Sure. I wanted to give you an answer, a two-layered answer. One from an insider, from a previous insider, and now from an outsider. And one thing that I learned from the Inter-American system of human rights is that it's a regional protection system that is very strong, but it's very imperfect, very imperfect. But one thing that for me was fascinating to watch was the issue of participation, especially when it comes to indigenous peoples. Y ahora continúo en español. Cuando yo veía a tantos pueblos indígenas movilizándose alrededor del sistema interamericano, y yo trabajé con todos los temas del sistema interamericano, yo estaba a cargo de las relatorías temáticas de distintos temas, y realmente para mí los pueblos indígenas era impresionante la movilización que tenían alrededor del sistema, y a mí siempre me ha impresionado mucho todo lo que han logrado ante el sistema. El tema es que los logros no son suficientes. O sea, al final del día, la situación es tan severa de contexto, de historia, de las realidades, que realmente lo que tenemos en el sistema interamericano es un granito al frente de todo lo que hay que hacer. Y yo, a pesar de todos los problemas que hay de implementación, porque hay muchos problemas de implementación, yo vi muchas medidas cautelares otorgadas que nunca se cumplieron. O sea, mucha gente asesinada después de que medidas cautelares se habían otorgado. Sentencias preciosas de la Corte Interamericana que han pasado años y años y no se han cumplido. Yo acabo de llegar de Belice, yo estuve en Belice en enero y todavía estamos negociando con el gobierno el caso de Maya Belice. O sea, la implementación. Un grupo de nosotros estamos tratando de llevar al gobierno a que realmente adecuadamente implemente este caso y trabajando con los pueblos indígenas maya para ver si podemos lograr algo. I just wanted to say that one thing in this imperfection is that for me, I was very privileged to be able to compare basically all this civil society mobilization that was happening with all these issues, and I thought the indigenous people's mobilization was particularly strong. And I think indigenous peoples have been able to obtain important achievements before the system and important language, but the problems are so severe on the ground that these achievements are not enough. There's a lot to do. And I was referring to, I just came back from Belize. I'm working actually with the government, but also the Maya peoples to facilitate compliance with the judgment that was adopted almost 20 years ago. We have a long way to go, but one thing that I've seen from the system that I think, and this was said by Ralph, that really differentiates it from anything else that I've seen in the world is the fact that we have hearings. The fact that indigenous peoples come there and can sit down with an ordinary government and actually discuss issues and negotiate issues and have that interaction with all these sectors, etc. And I also saw something that has stayed with me with the system is I saw a lot of people that knew this was important. A lot of commissioners that thought this was important. A lot of judges from the court that thought this was important. A lot of attorneys that were like, there's something wrong here and we have to address it. And I tend to be a positive person by nature, even with all the challenges, because if not, I cannot do human rights work. And the way, and the fact that I met all these people committed, and that there's all these young people sitting here and studying the system and interested in indigenous peoples, for me, gives me hope for the future. And I think we have to keep on striving to have a better future in international human rights law. Simplemente para resumir en español, que a mí realmente yo vi muchas cosas en el sistema que me dieron como esperanza de que realmente nosotros podemos llegar a un sitio mejor. Lo que pasa es que la magnitud de los problemas es tan grande y la complejidad es tan grande que hay mucho que hacer. Pero yo sí vi mucha gente comprometida, comisionados comprometidos, jueces comprometidos, gente joven, abogadas y abogados, que realmente estaban muy comprometidos con los pueblos indígenas y querían que la situación mejorara. Y yo realmente trato de ser positiva de que nosotros sí podemos mejorar, pero tenemos que trabajar todos juntos en esto, porque es muy compleja la situación.
Gracias.
Gracias. I love ending on this positive, more optimistic note for human rights activism. One of the things that's been going on is not only indigenous people more at the table, nothing about us without us, but also their own solidarities. And so as Juanita began with this wonderful example of indigeneity and solidarity at Standing Rock, I think we ought to remember that one of the ways that synergism can happen is as indigenous peoples talk to each other. And their leadership begins to push with a little bit more strength towards the idea of more governmental recognition and not just as sort of put to the side civil society, non-governmental organizations, or as Ralph mentioned, the terrifying government-organized non-governmental organizations. So I think we do have some reason for optimism within all the challenges. Thank you so much for coming. And let's give the panel a great hand.